Good morning, everyone. It's just turned 11 o'clock. So I've just started the webinar. I'm just going to give people a moment just to be able to join us. Good morning, everyone, and welcome to our March webinar. This month's webinar is an employment case law update where I will be talking you through some of the key cases that have come out, or some of the cases that maybe you haven't seen reported but still have an interest nonetheless. Thank you so much for everyone for joining us. Had fantastic response to this webinar, so thank you. And thank you to everyone who is a serial attendee as well. It's great to see those names popping up on the registration list month after month. So thank you very much for sticking with us and hopefully enjoying the content that we're providing to you. We are live and this broadcast is being recorded. So if you are watching us either on our YouTube channel or via our website, hello and thank you for finding us. So for those who don't know me, I'm Emma O'Connor. I'm a legal director here in the employment team at Boyce Turner and also head up our HR training academy. Boyce Turner is a full commercial law firm based in Reading in the Thames Valley, but we assist clients all over the UK and much further than that as well, providing full service of employment advice, employment support services, as well as immigration help as well. So if we can help with contracts, policies, reorganisations, redundancies, dismissals, recruitment, and workforce planning, then do please get in touch with us. As I said, we are live. You can post questions or get in touch with us after the event, and I'll be sharing with you information about how you can get involved and keep up to date. So as I said, one of my huge passions is training and development. And actually a lot of the cases that we'll be talking about today are ones where if I had a time machine and been able to go back and just, make conversations happen, make people have those fearless and courageous conversations with individuals. And one thing that we're able to do during, through the HR Training Academy is obviously bring you webinars, bring you our monthly webinar program. And as I said, fantastic to see huge numbers today. So brilliant. So fantastic you can all join us. But also to bring you other voices and other opportunities for training and development. And one of those is a course that I am running on the 10th of May. It's 90 minutes of your valuable time. But we're focusing on our mindset and how we as HR professionals, as HR leaders, as people managers, as business leaders, how we can improve our mindset. Because if we are more positive in our approach, and it's peaks and troughs, we can start positive at 9 a.m. and by 5 p.m, that's all dissipated, or it can be the other way around, of course. But if we're more positive, if we're more engaged, that obviously has an impact and a bearing on our teams, on our colleagues, on their engagement, and ultimately their productivity. So please do join us. It is a paid for course, small virtual group. You're probably thinking, well, hang on a minute, how does all this work? I'm joining with people that I don't know. In actual fact, it's a huge benefit because you get to meet and discuss issues through our facilitated leader, Rosemary Ryan of Represent, but also you get to meet other professionals in other businesses and find out how how they work, how they organize things. So actually, you get obviously the training and the top tips and techniques from Rosemary, but also we learn and develop and we grow together. So I'll be sending out the invite towards to you as well. So as I said, 90 minutes virtual, 9:30 to 11:30 in the morning. Join us. Fully interactive, so I hope you can do that. And I've had people asking me, Emma, when is the 2023 Masterclass? Well, here it is, 13th to the 14th of June in person, 2 days in our Reading office here with me, where we will be running the HR Masterclass 2023. What is the HR Masterclass, I hear you ask? Well, it's a course that has been written, that I've written and put together for HR. It is a specific course for HR professionals. So whether you are new to HR, you would like a refresher, if you would like to sort of boost your knowledge, get up to date with sort of what's going on in terms of the law and best practice, then come along. We are looking at those HR issues from an HR perspective. So what is your role with things like managing disciplinaries, managing complaints and grievances? What's it like to go to the employment tribunal? What do you need to know? How would you manage redundancies? How would you manage business reorganizations? What is data protection? What do I need to know? What do I need to do? Who is an employee? Let's go real back to basic stuff. So it is, as I said, it's for those who are new to HR, who have perhaps returned from a career break, a family leave break, people who want to just sort of, upskill their knowledge. So yes, it is 2 days, 9:30 till 2:30 every day. So that kind of fits with people's working patterns. Small group, again, classroom style, but super excited, and fantastic feedback from this course every year. And it's brilliant to see some of my previous alumni going on to take HRD roles, have moved from perhaps sort of an accounts role into HR. It's wonderful. So I do hope that you're able to share that invite and get people to come along and join us. So yeah, lots happening in the world of the Boys Turner HR Training Academy, as well as case law, which is my little segue into what I want to talk to you about today. But I thought before we would sort of dive into cases, I thought we'd take a little step back and have a look at sort of the state of play. Where are we in terms of the employment tribunal and employment tribunal statistics? So we are a little bit behind in terms of when the statistics are published. So we've had published the statistics from the last quarter of last year. So as I said, we're still waiting obviously to see how things are sort of panning out. So we've got the statistics for July to September 2022 have been published. And I thought it'd be quite interesting just to have a little chat and sort of share with you what's going on, because there is a lot going on in employment tribunal land, and sort of from our perspective in terms of what we're seeing within our team. We are certainly seeing an increase there in terms of cases being brought. And that is reflected in the tribunal. So although overall there has been a decrease in the amount of cases that are being brought to the tribunal, and again, this isn't internal conflict, complaints, grievances. This is actual physical ET1, so physical claim forms being issued in the employment tribunal. So there has been a decrease if you compare the period in the previous year. So there has been a decrease in the amount of cases that have been brought. But what we are seeing is an increase in the single claims. So the way the employment tribunal breaks things down is they break it down into the amount of single claims that are brought. And single claims are one claim. It could be multiple claims, so it could be an unfair dismissal plus a discrimination claim plus a bit of unfair unlawful deduction of wages claims, but it's one claim brought by one claimant against one individual. So there has been an increase in single claims that have been brought. But what we have seen in the tribunal is that there's been a decrease in the multiple claims. So there I'm talking about claims where you have multiple claims that are brought by lots of claimants, typically for the same thing. So lots of holiday pay claims, or lots of equal pay claims, or lots of unlawful deduction of wages claims. So you get those sort of, mass claims. So there has been a decrease in those claims. Rather worrying, perhaps, is that we've only seen the tribunal being able to get through an additional 6% of claims. So we do have quite a bit of a backlog. So by the end of September last year, there were 493,000 outstanding claims, and of that, 448,000 were the multiple claims. So as I said, multiple claims, and 45,000 of those were single claims. So there is still a way to go. There is still that backlog, and some of you listening today may sort of be finding that you've got claims that have been brought by ex-employees that are still continuing, and that can cause issues because memories fade, evidence, etc. Are your witnesses still employed within your own organization? So there's lots of things to think about the longer claims obviously continue for, and obviously for claimants as well. We don't want this hanging over them also. Much of my job is spent risk assessing. So when claims are brought in, we have a discussion with clients around, what is the likely prospect of success here, and what is the likely compensation. And I think if you have those discussions early, I think it can very much help in the approach to the litigation. So just in terms of compensation, because I know that's probably the first question you'll ask, how much is this going to cost? Well, we do have some figures that have been published for compensation. Now, in terms of unfair dismissal compensation, so the average, so the mean tribunal claim there, the compensation there was just over £13,500. Now, as we know, with unfair dismissal, so the main unfair dismissal claims, talking about sort of automatic or whistleblowing there, we do have this cap on compensation for unfair dismissal. And when I started in employment law, it was £11,000. We are seeing now from April this year, so for dismissals or terminations on or after the 6th of April 2023, that's going up to, with basic award, redundancy pay, well over £100,000. Yes, that's capped at 12 months salary, whatever is the lower. But certainly, unfair dismissal is potentially incredibly burdensome for employers. So, yes, the mean is just over 13.5, but that doesn't necessarily reflect where the actual risk may be. Now, discrimination cases, slightly different way of calculating compensation, based, yes, on an element of loss of earnings, if an individual has had to leave their job or they have been dismissed, or if they've got sort of during employment losses. But discrimination compensation has this element of compensation for injury to feelings, if there's been any personal injury, the duration, the campaign of bullying, harassment, less favourable treatment. And in discrimination cases, that compensation is not capped. So we don't have that cap that we have in those sort of, day-to-day claims for unfair dismissal. So just to give you a bit of a flavour from the statistics that were published by the Employment Tribunal Service. So the maximum award for compensation for indiscrimination last year, or up to September, was £228,000, and that was in a race discrimination case. And then the second highest discrimination award, again, looking at September, period up until September last year, was nearly 226,000, and that was in a disability discrimination case. So you can see that in those discrimination cases, the compensation there is potentially much, much higher. Now, a word as well about compensation. So as I've said, where you've got those, I would say the sort of ordinary unfair dismissal cases, so capability or conduct, where you do have the cap applied. There are also other claims for unfair dismissal, and one of those is where there is an element of whistleblowing, and in those situations there is no cap on the compensation for unfair dismissal resulting from a whistleblowing claim. And for whistleblowing claim, the highest figure there was £165,000. So, there are compensation issues. So we've got this backlog that's obviously going to have an impact as we move forward in the Employment Tribunal caseload. And it's interesting to see as well, we're seeing cases again being sort of, booked for hearing sort of way down in the diary. Obviously that has an impact as well in terms of planning for businesses. So we do still have that backlog. But there are obviously some takeaways from what we're seeing. And, really it's kind of going back to that, where is the awareness within organizations, particularly around discrimination issues? Where's the training? So are we training our managers on, on our processes and our procedures? So would a manager know how to undertake an investigation process? Do they know how to write a report? Do they know even what their role is in a disciplinary or a grievance scenario? Does HR know what their role is? Again, perhaps more importantly, having clear processes, having those clear procedures, do your managers firstly know where to look for things? Do they know how to raise issues if they have them? Do they also need to talk about things, in terms of how easy are their processes to review? So I think, there's some things there we need to have a think about. And again, we're running training sessions for managers, real bite-sized or day-long sessions where we focus on what their obligations are and how they actually approach things like, disciplinaries, like grievances, performance issues, the importance of appraisals, etc. So with that backdrop, let's have a look at where we are in terms of, so just had a question there on constructive dismissals. The tribunal don't tend to sort of break it down in terms of what the dismissals are. They tend to sort of focus on what dismissal is in total. For those who don't know, constructive dismissal is where an individual resigns from employment. So they do leave employment, but they are leaving because of the actions of their employer. So they still need that 2 years service, that magic 2 years service for those sort of basic unfair dismissal award claims. But there you're looking at a scenario where it's, the straw that broke the camel's back. So, what is it that the employer has done? Have they breached that mutual trust and confidence, that bedrock, that absolute foundation of the employment relationship? And again, has the employer acted in such a way as to allow the employee to say, that's it, I've had enough, I can't work for you anymore, the trust and confidence is gone, and I'm going to resign. So, it is important, and yes, compensation claims, etc., can flow from that as well. So let's get down to business, shall we? Let's look at where we are in terms of some of the key cases from back into last year and obviously into 2023. So the first one, unfortunately, is a little bit of a head-scratchy one. We have had laws around holiday and holiday entitlement since 1998 under the working time regulations. But those of you who've been involved in employment law in HR will know that they probably make up, most of the kind of headline cases every single year. And one would have hoped that after such a long time that we'd be a little bit clearer in terms of how we calculate holiday pay, who gets holiday, how are we going to work it out, how is this all going to play? The answer is we're not quite there. We're not quite there yet. So what we know is that obviously under the working time regulations, we have basic holiday entitlement, and it is basic, it's statutory minimum entitlement that applies to not just employees, but to this category of worker as well. And as we've seen, as I've talked about on previous case law updates, we've got that sort of scenario. Well, I'm a worker, I'm an Uber driver, I work for Pimlico Plumbers, I work for Deliveroo, I'm a worker, therefore I should get my entitlement to my holiday because that's an entitlement, that I have an entitlement to because of my status. I'm not self-employed. So that's some of where we've potentially seen those sort of cases coming up as well. So essentially we have this basic EU entitlement, and that's to 20 days, in a holiday year. And then the UK decided to increase that by another 1.6 weeks. So essentially we have an entitlement to 5.6 weeks of holiday in a holiday year. That's the sort of the statutory entitlement, if I can call it that. Obviously, employers are entitled to sort of manage that and increase that how they want to and how they juggle bank holidays. So the 5.6 weeks would include that, but obviously it's probably, I'd say, pretty standard for employers to have a standard amount of holiday plus bank holidays as well. But the world has moved on, people work in different ways, and I think, and my view on this is that whilst we've got laws, they're not really keeping up to date with how people are kind of doing the work thing now and how they're working and what contract that they're working under. And I think the case of Brazil is really kind of a really good example of this. So Ms. Brazil, she was a music teacher, and she didn't work the full year. She was a permanent member of staff, but she worked on a part year 0 hours contract because it depended on what lessons, what private lessons, etc. that she was teaching. So she probably worked between 10 to 15 hours a week, but she had a permanent contract even though she worked part year, i.e. she worked term time. Now, the trust with whom she worked for, they calculated her holiday pay based on ACAS guidance. So ACAS, brilliant, lots of good guidance on their website. We've got our codes of practice as well that we have to follow, particularly disciplinary grievance, etc. So great. So off they went to ACAS, and ACAS's guidelines at the time said, look, calculate their holiday pay based on 12.07%. Which was the proportion of holiday against the working year, so the number of hours, the number of working weeks, etc. So they calculated her holiday pay based on what ACAS told them to do. But Mrs. Brazil said, well, no, I'm sorry, that's not the right way to do it. You shouldn't discount the weeks in which I don't work. You shouldn't use this 12.07%. In actual fact, I should be entitled to the full holiday entitlement. Thank you very much. But obviously the employer said, well, no, we're doing what ACAS has told us. You don't work you don't work full time, you work part year. So therefore we've worked it out accordingly. And if we didn't do this, you'd actually get more holiday than somebody who was part-time, but did work the full year. So where did we get to? Well, I think, again, what this case demonstrates is not only that the law hasn't kept a pace with the way people work and how they work, but also it's got this tension between what is holiday. And it does go back to this idea that holiday isn't, a benefit or a nice thing to have. It's actually a health and safety requirement. And again, I think we see this conflict in the case law between what is actually holiday pay. So this case actually went all the way to the Supreme Court, and that's again important because it shows the lack of clarity in the working time regulations of how we should calculate holiday pay in these sort of, ways in which people are working now. So it went all the way to the Supreme Court, the top court in the UK. And basically what the Supreme Court said was that all workers are entitled to 5.6 weeks of paid holiday every holiday year. And that's what it says in the working time regulations. And in the absence of any clear guidance within the working time regulations, what the Supreme Court said is that holidays should be worked out and paid on a worker's average weekly pay over the previous 52 weeks. And crucially, that employers should ignore any weeks where the worker or the employee did not work. And that's the crucial bit in this judgment. It's the fact that the Supreme Court is saying you take the whole year, you don't take out the bits where the worker or the employee did not work. So again, the effect of this judgment is potentially huge. It's huge for those businesses, those employers, those sectors. So education, exam invigilators, peripatetic music teachers, summer sports coaches, retail, leisure and hospitality. But the key is it's for those individuals who are on a permanent part-year contract, permanent. So not our temporary people that are just engaged for a few weeks or months. Again, they are entitled to holiday and holiday pay, but we're talking here, so the Brazil case is about those individuals who have that permanence to their employment or their work with you. So a huge impact there. And, again, there's this difference, isn't there, between our part-time workers whose pay is prorated against full-time equivalent, and then our part-year workers who are obviously treated, more favourably by this judgment. So we've got this case, it's there, it's, it is the law, but obviously there's been a huge uproar about this, and absolutely, because there is this difference in the legislation, and the legislation, as I said, has not kept a pace with how people are working. So what did the government do? Well, they, to be fair, they acted very quickly in terms of getting some consultation out there. So the consultation closed in March. So as a firm, we put in consultation, particularly for our leisure and hospitality clients. So we worked with leisure and hospitality sector to put together some consultation, some responses to the consultation. And basically what the consultation aims to do is reverse a Supreme Court judgment, because obviously, no other case can go against that, because that's, the highest court. The only way it could be changed is obviously if legislation is brought in to do that. So that's what's been proposed. So rather than you take the full 52 weeks, even irrespective of whether somebody has worked the full 52 weeks, what the consultation and what proposed legislation is saying is that what will happen is, yes, you'll take the 52 weeks to work out what holiday and holiday pay will be, but you discount the weeks. So you take them out where the individual has not worked. So completely reversing, obviously, the decision of the Supreme Court. And, the government have to put in, so when they do their consultation, they have to put in an impact assessment. And they've assessed that if this change was made in the law, that it would save employers around about £113 million annually. So, a huge change and a huge impact there. So we are where we are in terms of the decision. So we need to look at our workforce. We need to work out exactly who may or may not be impacted by the Brazil decision. We need to take advice on that to see where we are, what we can do. We need to obviously assess the impact in terms of where the risk might be in terms of unpaid holiday pay. And we also need to watch, don't we, and see what's going to happen. And, the speed at which the consultation came out, one would hope that would mean that we can get some legislation in pretty speedily as well. Also going to raise, so those of you who joined our January webinar will have heard me talk about the retained EU law bill, the rather snappily titled retained EU law bill. So again, there's lots of things happening, lots of discussions around EU law. Don't forget, holiday pay is an EU law. Holidays is an EU law, derives from EU law. So, there's lots of changes that could be afoot here. Whether there are any other tweaks or changes to the working time regulations, ministers have a sort of until the end of this year, use it or lose it type approach. But what I would say is, if consultations do come out about, particularly around things that affect your business, so agency workers regs, which I'll talk about later on, holiday, get involved in the consultation process, make your views known. If you've got a trade body or an association, again, get involved, because, there is an opportunity perhaps to be able to make some worthwhile changes and get some clarity around some of these issues. So the next case I want to talk about is around the subject of legal professional privilege. So many of you that have been involved in either a subject access request, so under the data protection laws, individuals can make data subject access requests, and also where you are involved in, potential or actual litigation, will have probably been told by your lawyers that you don't need to disclose certain documentation because it is legally professionally privileged. So legal professional privilege, whether a document has legal professional privilege, is a question of fact. Okay, so we can say it does, but at the end of the day, a judge may decide that it does not. But essentially, it is for those documents, that communication, so emails, letters of advice, reports, etc., that are compiled by lawyers for the purpose of giving or obtaining legal advice or being used in pending or contemplated litigation. So it's not copying your lawyer into every email that you send internally. That is not legal professional privilege. You're not asking your lawyer to give you legal advice or make comment and give legal advice. So there is quite a clear distinction here. So we're looking at that primary purpose. What is the primary purpose of the document that you are saying has legal professional privilege? And the University of Dundee and Chakraborty case really delves into the sort of, murky world of legal professional privilege. So what happened in this case? Well, Mr. Chakraborty was a research assistant at the University of Dundee, and he raised allegations of bullying, discrimination, harassment, and racial abuse against his line manager. Now, in accordance with the university's grievance procedure, they had to put together a panel, and a professor, an external independent professor, was appointed to review and investigate the complaints that had been made. Now, they put together a report, and that report was obviously discussed internally within the university, was not shown to Mr. Chakraborty at that point. So a month after the report was published, the university then said, well, we need to get some legal advice on this. So the original report then went to lawyers. The report then came back. So where are we now? Version 2. Version 2 came back. And then there seems to have been a bit of a version 3 and a version 4, where both the lawyers and the investigating professor got involved. And then a final version 4, if we'll call it that, was then disclosed to Mr. Chakraborty. Now, rather, I don't know, haphazardly, on the front of the report, because you're probably thinking, well, how did he know? How did he know that there were 4 versions of this report? Well, rather helpfully for Mr. Chakraborty, but perhaps unhelpfully for the university, on the front of the report, and I'm going to read what it said, it says, note, this report was amended and reissued on the 23rd of June 2022 following independent legal advice. So, surprise, surprise, Mr. Chakraborty, this issue ended up in an employment tribunal, and the claimant then said, well, I'd like to see a copy of the original report, please, not version 4. So I'd like to see that report. And the university said, well, no, you can't see that report because that's legal. That has legal professional privilege. Now, remember that courts, the employment tribunal, courts in general, have greater powers of disclosure. And that's the same whether it's a without prejudice, document, conversation, or legal professional privilege. So the courts do have extraordinarily wide powers when it comes to disclosure. So even if you say something is legally professional privilege, in actual fact, the tribunal does have some issues there in terms of what we're looking at. Sorry, I just had a question in there and I'll deal with that probably offline. So Mr. Chakraborty said, well, I'd like to see that document, thank you very much. And went to an employment tribunal. And then it was very interesting to see what the tribunal decided. So the university had to concede that document 1, so version 1, was not legally privileged, because the purpose of that report wasn't to seek legal advice. The purpose of that report was to deal with, investigate a complaint that had been raised. So there wasn't any legal privilege in that document. But what the university said was, well, although there isn't privilege in that document, actually there is retrospective legal professional privilege in version 1, because we sought legal advice on version 1, which then ended up with version 4. So you can't disclose version 1 because it's actually all part of the seeking of legal advice process. And also, if you do reveal issue 1, so version 1, and you compare that to version 4, which is the one we have disclosed, you can infer the legal advice that we were given by our lawyers. So, for example, and I don't know, it might be that version 1 said something about a comment which had been made or a best practice that had been made, a recommendation, and it might be that had been removed in version 4 on legal advice, and perhaps then, you know, an inference could be made as well, so you're not doing that and you're not doing this, and so this was said, and how's that, you know, so you can kind of see how the argument would go. But in actual fact, the Employment Appeal Tribunal, so this went to the Employment Tribunal, disagreed with the university, and they said, no, we can't, you know, document 1 is disclosable. The whole reason why it was produced was not for legal professional privilege reasons. It was to, you know, drive forward this investigation. And also, you know, you can't get retrospective legal professional privilege. It's that document that is produced, or that advice that was given. So, you know, you can't have the best of both worlds. And also, yeah, you know, it might infer the legal advice that was given, but again, that's a consequence. It's not the fact that that document, that version 1, has legal professional privilege. So some takeaways from this case. I think if you are considering, or you think that you know, a case may go further than simply you know, an internal investigation, then, you know, get advice early from your lawyers to sort of maintain that professional privilege advice. And also, you know, again, you know, think about the fact that, you know, our documents, our evidence, what we write down, our emails, you know, our notes, our, you know, our things that we send, you know, potentially they are all disclosable. So again, think very carefully about what you are writing, what you are sending. And as I've said, copying emails into your lawyer is, you know, it's not professional privilege. So it won't protect you. So an interesting case there in terms of documents and disclosure more widely. The next case I want to look at is, again, it's a discrimination case, but this is focusing on disability discrimination. Not just disability discrimination, but also, you know, we must remember that whilst, you know, you can bring claims for direct disability discrimination, indirect victimization and harassment, there are other claims that can be brought within, you know, the sphere of disability discrimination, which often employers forget, I think. And it's something that I've been really focusing on in the EDI training that I've been doing with clients recently. You know, what are all those, you know, where are all those risk areas? The disability-related discrimination. So we're not dismissing you, or we're not treating you this way, or we haven't made this decision because you have a disability. We're doing it because of something associated with it. And you'll see that when we talk about this case here. And also that positive duty on employers to make those reasonable adjustments. And again, really easy to get wrong and really easy to, you know, fall foul of tribunal judgments. So let's take a look at the Jandu case. So Mrs. Jandu, she had been employed by Marks and Spencer since 1998 until 2020, when she was made redundant. And from 2023, she had been employed as a layout planner. She had been open with her employer about her diagnosis of dyslexia. So Marks and Spencer's were, you know, had full knowledge of her disability. Under the Disability Discrimination Act, under the Equality Act. So she was very open about that. And in 2020, Marks and Spencer's went through a redundancy, exercise a redundancy program, and Mrs. Jandu was assessed against several criteria, as others were as well. And she actually was selected for redundancy on the basis that she scored particularly low in the consistency and accuracy of communication heading and written work. Now, Mrs. Jandu, when she saw those scores, inquired of her line manager and said, well, hang on a minute, what's going on there? I suffer from dyslexia. I suffer from dyslexia. Why have you scored me down on these areas where that these are particular areas that I find difficult, that I've raised that with my line manager? I find writing an email is the worst part of my day. And also, before the redundancy process, the claimant had raised concerns with her manager seeking help. She'd also asked for support, extra support around colour coding of long emails and some help with proofreading. But Marks and Spencer's had done nothing about this. They hadn't referred her to occupational health. They hadn't sought advice for occupational health. They hadn't considered whether the adjustments that she was asking for were reasonable, that would have helped her and supported her in her role. Mrs. Jandu was made redundant, and she brought claims in the Employment Tribunal for unfair dismissal and also disability discrimination. And Marks and Spencer's was really slammed in this judgment. They failed to make reasonable adjustments. They didn't, they weren't proactive. They didn't take advice. They didn't seek occupational health reviews or reports or give this employee the help that she was asking for. They hadn't been proactive. They'd used impact. They've used the impact of her disability to then score her down in the redundancy process. So they haven't, ignored, the consequences, the impact of her condition. They'd actually, as I said, selected her on the basis of the impact that it had. So, there were some real learning points here, and that was reflected in the compensation. So, this individual was awarded over £50,000 worth of compensation, and that included £20,000 in terms of injury to feelings, which is high. That's a high award for injury to feelings, that damage that the action has caused to the individuals. So what can we do and what can we learn from this case? Well, again, it's, training managers, that awareness, being proactive, not waiting for problems to arise, taking steps at the start, getting HR involved, getting occupational health involved, and when you're going through that redundancy exercise, training managers on how to apply criteria and how to fairly apply criteria. Are we moderating those scores? Are we making sure that we're applying those criteria in a fair way, in a way that is compliant with our obligations under the Equality Act? And again, the wider piece, training, awareness, making sure that we're complying with our duty to make reasonable adjustments. Remember, if there's a reasonable adjustment that could have been made and is not, there is no defence to that. So again, some important lessons to be learned from that case there. Marital status and civil partnership discrimination. What is that? I hear you cry. Yeah, and you'd be, right in thinking, oh, is that really a ground? Is that really a protected characteristic? Because these cases come up so rarely. Now, part of the training, part of the legal training that that we run, that we deliver for managers and leadership populations. So part of that is going through what the protected characteristics are, because if you don't know what they are, have examples of what they are, it's really hard to understand what the potential risks might be. And again, that legal training is so important when we think about trying to have that statutory defence in to discrimination claims. Not enough just to have a policy. It's not enough just to put a few posters up. What are we doing? It's that legal training, that compliance training that's really going to sort of put you in the best possible place of being able to have that statutory defence. So part of the training that we do is we look at the protected characteristics and we give examples. So obviously one of the protected characteristics is marital status and civil partnership status. How do you describe it? Well, thank goodness for the case of Ellis. although when I'll tell you about the facts of it, it's not particularly nice. So discrimination for marital status and civil partnership status doesn't come up very often, very, very rarely. But what it is, it's being treated less favourably and to your detriment because of the status of that status of being either married or being in a civil partnership. There's no reciprocal protection for an individual that is not married or not in a civil partnership, is proposing to enter into marriage or enter into a civil partnership, or for somebody who's been divorced or has had that, that civil partnership dissolved. So it's the act of being being married or in a civil partnership. So it only applies to employment claims brought in the tribunal, and it is for less favourable treatment. It's not being harassed for being married or in a civil partnership. So in this case, the claimant, she worked for a business, and as well as working for a business, she was also married to the majority shareholder in that business. Unfortunately, there was a relationship breakdown, and husband and wife were going through a very acrimonious divorce. And during that relationship breakdown period, the employer took it upon themselves to do various things to this individual, to this married lady. They called the police on her. They raised and they sort of put various allegations to her, and in the end she was dismissed. So she brought a claim in the employment tribunal which said, look, I've only been treated this way because I'm married to the majority shareholder. It's marital discrimination. I wouldn't have been treated this way if I wasn't married to him. And the employment tribunal accepted that, and she won her case. But the employer appealed to the Employment Appeal Tribunal, and they and again, it was a judgment, and you don't often see the Employment Appeal Tribunal saying it is with a heavy heart that we have to make this decision, but they drew a distinction. And what they said is that in discrimination cases, you have to have a comparison. So who is your comparator? And in a marital or civil partnership discrimination case, you are comparing yourself to someone who is not married or in a civil partnership. So could this claimant, could this married woman say that if I wasn't married to this individual, if I was in a long-term relationship with this individual, would I still be treated the same way? And unfortunately, she couldn't. So the argument was, and the Employment Appeal Tribunal accepted that the less favourable treatment was not because you were married to this individual. If you had been in a long-term relationship with this individual, you would have been treated in the same way. So there is that distinction. And I do think it's potentially going to make it harder for individuals to be able to argue that the treatment is because they are married and not just because they're in a relationship with an individual. So an interesting case. It just shows you that these issues do crop up from time to time. And again, it does reinforce that point in discrimination law that it has to be, you have to have a comparator, even if it's a hypothetical comparator, but it's that, being treated, how person A was treated when compared with person B. And that's really important to remember. So as well as being a busy sort of, 6 to 12 months, it's also going to be a busy year. So we've got a few cases coming up. The first one there is, again, it's another horrible holiday pay case. So there was a flurry of activity with holiday pay cases, a number of years ago, which resulted in case involving Fulton and Bear, Scotland, in which the courts at that time said that if you want to bring a claim for unpaid holiday pay, you've really only got, if there's a break of 3 months between the payments, then that sort of cuts off that ability to be able to argue a series of deductions, a series of losses. And but the Court of Appeal in Northern Ireland is the courts in Northern Ireland are saying, well, actually, no, we're not going to follow that guidance. And what they're saying is that in actual fact, you should be able to go back for 2 years. So taking out this sort of, gap, this breaking claim. So That doesn't apply in England, Wales and Scotland, but you know, it's a watch this space, because this case is coming to the UK Supreme Court near you. And obviously that could have a massive implication for employers and their liability and their back liability for holiday pay claims if the Supreme Court decides to either stick with the sort of England, Scotland, Wales position or adopts the Northern Ireland approach. So again, that's going to be one to watch. Another issue is agency workers regs. They do crop up, they do cause a few headaches, particularly when we think about the rights that agency workers have from day one, and also after 12 weeks in the same job with the same business. And one of those is the right to be told about job vacancies. And the next case there of COCOR, that's talking about, well, to what extent is this duty to inform individuals about agency workers about vacancies? Yes, we know there is a duty to tell agency workers, but does that extend to a right to apply? And this is particularly relevant to employers in a redundancy situation, where for your employees who have been selected at risk of redundancy, you then go into consultation mode with them. Part of the consultation process, as we all know, is that duty to look for suitable alternative employment. So how does that duty to look for suitable alternative employment for our employees, how does that work with the duty to inform individuals who are agency workers that qualify for the right? How do those two rights interplay? So that's going to be quite an interesting one, and could be potentially problematic for employers. Asda and Tesco's fire and rehire. This is the practice which employees and unions don't like, which is where if you wish to implement a contractual change, changes to terms and conditions of employment, then subject to rights for collective consultation and things like that. So again, it's not a you can do this. There are lots of other rules and lots of other laws that kind of kick in. But ultimately, if after you've consulted on a contractual change, employees don't accept the change, you can end employment giving notice under the current contract and rehire under the more favourable in the employer's mind under the new terms. And this is what Tesco's sought to do. We saw it with P&O ferries, but obviously Tesco's sought to do this as well. They sought to remove the right to enhance contractual payments in staff, so fired and sought to rehire. So we've got that case going through. But we've also got proposed government consultation on this. There is a proposed code of practice, an ACAS code of practice on the on how we can make, not doing away with firing and rehiring, just making the practice more reasonable, consultative, and making sure that we've followed that reasonable procedure. And again, if that consultation does go through and we get that code of practice, there is a potential there for uplifts in compensation. So again, this is one where I think hiring and refiring is obviously going to be on the agenda. Striking as well, we've got sort of laws going through Parliament at the moment on that, minimum service levels, etc. But ultimately, under the Trade Union and Labour Relations Consolidation Act of 1992, there is protection from employees from being dismissed for taking part in lawful strike action. The case here involving the Alternative Future Group is to what extent are employees protected where the employer is seeking to do other things to deter them from taking part in strike action. So, for example, taking away or seeking to remove discretionary benefits and making it less attractive, making it difficult. So not dismissing, but making it difficult for employees to take part in strike action. So again, we've got that case, the Supreme Court case, being decided later on this year. So lots of things to watch out for, and to help you and to guide you, we've obviously got our webinar program, our monthly webinar program. So if you're not already receiving our newsletters. If you're not already receiving our invites, then please do so, and I'll be sending out information on how you can do that. But next month, we're going to be looking at the do's and don'ts of employment litigation process. So get your questions in. If you want to know what an unless order is, if you want to know if your costs will be paid in an employment tribunal, get those questions in, and we're going to be doing a kind of online sort of Q&A on that. So please do email in the questions. So really super excited about that case, that webinar that we're doing. And then in May, going to be doing something around feedback. How can we give fearless feedback, and what might that look like, and what's feedback as opposed to discussing people's behaviour? So really excited to be able to looking at that as a topic. And again, don't forget, we've got our public courses that we're running. We've got our Building a Positive Mindset course, that we're running on the 10th of May. It's 90 minutes out of your day. You'll get your tips, your techniques. You can start learning. So do please join us. And it's great that people join, and we all join and we learn together. So really excited about that. And again, watch out for invites on the HR Masterclass. If you want to hear more about us, if we can help, here are our contact details. And again, I'll be emailing all of you later on, just to give you a bit more information about the things that we've talked about today and how you can get involved. So thank you so much for everyone for joining today. I mean, the numbers today have been incredible. So thank you so much for supporting what we're doing. If we can help, then get in touch. If not, I look forward to seeing you on the 10th of May at the virtual training course, and also at our next webinar, which is at the end of April. So enjoy the rest of your week, and look forward to seeing you all next month. Thank you very much, and goodbye.